Ready? 1, 2, 3, start. In answer to the suit summons, the defendant number 1 appeared through his counsel and filed written statement contending that the suit of the plaintiffs is not maintainable either on law or on facts. Further denied all the allegations made in the plaint. It is specifically submitted that defendant number 1 is only legally wedded wife of deceased Bhimappa, and out of her wedlock with Bhimappa she had given birth to two sons and four daughters. The younger son of defendant number 1 by name Mayappa has died, leaving behind his wife and children. Bhimappa, the husband of defendant number 1, died intestate on. It is further submitted that defendant number 1 along with her sons and daughters have succeeded to the suit properties. The elder son of defendant number 1, that is defendant number 7, has gone in adoption to one Gaurabai Chintamani Pawadi of Siddhapuravadi village, Taluka, Chikkodi. As per the customs and tradition prevailing in the community, on 29/9/1984, the adoption deed was reduced into writing and was registered before the sub-registrar Chikkodi. The defendant number 7 gone in adoption and all his rights with genitive family were served. Now the defendant number 7, in colluding with the plaintiffs, has managed to file this suit with the intention to grab the valuable rights of defendant number 1. It is submitted that the plaintiff number 1 has given in marriage to one Parasappa Adinavar of Melavanki in Gokak Taluk. The plaintiff number 1 is alleging that she is second wife of Bhimappa and she is not legally wedded wife of deceased Bhimappa. But it is further urged that the plaintiffs and defendant number 8 are no way concerned to the deceased family and suit properties. Further denied all the allegations made in the plaint, hence prayed to dismiss the suit. Next para. Further, the defendant number 2 filed memo adopting the written statement filed by the defendant number 1. The defendant number 7 filed written statement adopting the contentions of the plaintiffs. It is submitted that the plaintiffs and defendants are the members of the joint Hindu family and the suit schedule properties are the ancestral and joint family properties of plaintiffs and defendants. Further admitted all the contentions urged by the plaintiffs and prayed to decree the suit and to allot 1 by 11th share to the plaintiffs as well as the defendant number 7. Hence, prayed to decree the suit. On the basis of the pleadings, my learned predecessor in office had framed the following issues: whether the plaintiffs prove that the suit schedule property is ancestral and joint family property of plaintiffs and defendants, whether the plaintiffs prove that they are entitled legitimate share to the suit schedule property, whether the plaintiffs are entitled to relief as claimed in the suit, what decree or order, whether the defendant number 1 to 6 prove that plaintiff number 1 is not the legally wedded wife of deceased Bhimappa, whether the defendant number 1 to 6 prove that the plaintiff number 2, 3 and 8 are not born to plaintiff number 1 through deceased Bhimappa, whether the defendant number 1 to 6 prove that defendant number 7 is the adopted son of one Srimati Gaurabai Chintamani Pavadi, whether the suit is bad for non-illusion of family properties. Next para. In order to prove the case of the plaintiffs, the plaintiff number 2 examined himself as PW1 and got marked Exhibit P1 to P12 documents and examined one witness by name Bhupal Maruti Uppar as PW2. On the other hand, in order to prove the defense of the defendants, defendant number 7 is examined as DW1 and got marked Exhibit D1 to 6 documents. The defendant number 3 is examined as DW3 and got marked Exhibit D7 to D36 documents on behalf of defendant number 7. He got examined one witness by name Kallappa J. Nayak is examined as DW2. This court heard the arguments of both the erudite counsel appearing for plaintiffs and defendants, perused the written arguments filed by plaintiffs and defendant number 7. Additional issue number 1 and 2 are interlaced with each other, so on aloof discussion will also come to same conclusion. As such, these issues are picked up together for common discussion in order to avoid repetition of facts and circumstances of this case. These issues are the crux of dispute between the rival parties, and these issues clinches the whole dispute in controversy. As such, these issues are taken for discussion at the inception. The plaintiffs have knocked the doors of justice with the relief of partition and separate possession, and almost a decade found legal combat come up for disposal after encountering many of legal and technical barriers. Before I dwell upon the factual matrix, I may profitably dwell into the conceptual aspects with regard to suit for partition. The necessary requirements for filing the suit for partition and separate possession are that there must be unity of title and unity of possession between the plaintiffs and defendants. That is to say, both the plaintiffs and defendants should have joint title and joint possession in the suit scheduled properties. Thus, the legal relationship between them should be that of a co owner or co sharer or co parcener.